My question is to the Attorney-General. The Vincent Review, as it's commonly referred to, was a review of the Open Courts Act and the way Victoria suppresses information pertaining to court proceedings. We are, after all, often termed the suppression state. Figures just out today reveal that we are home to more than half of the country's suppression orders. The report and its 18 recommendations were handed down in September 2017, with Premier Andrews saying that 17 of the 18 recommendations from the independent review would be fully implemented in this term of government. Your government surprisingly remained guarded about the last recommendation, a public interest monitor, or as I like to refer to it, an open justice advocate. Attorney, is this commitment to implement 17 of the 18 Vincent Review recommendations before the next election still the government's current position?
Thank you, President. I thank Mr Grimley for his question in relation to the Open Courts Act review and indeed, as it's termed, one of the Vincent reviews. And there has been significant reforms in response to that report into making our justice system more open and transparent, whilst of course safeguarding the privacy and rights of victims. In relation to your comments in relation to the public interest monitor, this recommendation was marked as for further consideration in the government response to that review, reflecting that it's a novel and complex recommendation and would create a role for the public interest monitor not seen in any other Australian jurisdiction and quite separate from the PIM's existing functions. The Department of Justice and Community Safety is continuing to consult on this recommendation about whether it could be implemented, but these issues are certainly not straightforward. And I'm hoping to have more to say in due course, Mr Grimley. In the 6 months that I've been in this role, I'm very keen on talking about justice issues. The bill that has been introduced into the lower house today aims to do exactly that, particularly encouraging victims of sexual offending to be able to talk about that, to destigmatise the issue and encourage victims to be able to come forward and report these issues. So these are important matters, but in relation to this report, Mr Grimley, it hasn't been at the top of my priorities in the 6 months that I've been in the role. However, thank you for your question, and I endeavour to provide an update in due course.
Mr Grimley on a supplementary.
Thanks, President. Thank you, Attorney. Last year, the government rectified mistakes it unintentionally made regarding sexual assault survivors being able to name themselves in the context of being a survivor. Amendments passed in this place that ensured the next set of JPRA changes in regard to deceased sexual assault victims will be finalised before the repeal of Section 4B. Recommendation 100 of the 2020 VLRC report was further reinforced in case law by Judge McInerney's decision in Jamie Lee Page's case last year. Judge McInerney said Ms Page didn't need his permission to name Carol, as naming deceased victims of sexual assault had always been lawful. I understand, according to a media release this morning on the Judicial Proceedings Report Bill, I understand that this establishes a victim privacy order. Attorney, can you update the Chamber on how this bill will conform with our open justice principles, and can you ensure that the latest amendments will ensure that families of victims will continue to have a voice should they wish it to be heard?
Attorney General.
Thank you, President, and that's a really big question for a minute response, and I'm sure we can go through these issues in great detail when the bill comes to the upper house. The purpose of the amendments that are going through the Parliament in the next couple of weeks are about enabling family members to speak openly about their deceased loved ones who have been victims of sexual assault. I have consulted extensively with families that are great advocates in this space and heartbreaking that they're in that situation. So the bill seeks to balance the interests of those who wish to speak publicly about these events, as I've said, to destigmatise, to talk about the issues, to encourage reporting of other victims, but also balancing the interests of those families that may find it particularly distressing to have those details in the public, which is why there is the victim privacy order avenue for those small amount of people. But again, very happy to take this offline and have conversations, and indeed the bill will be in the Parliament next sitting week.
Mr. Statement.